Welcome to Middle Class Matters. Business News in English from Dr. CMA MBA Allegation, 17th June 2023. Report of the expert committee constituted by the Honorable Supreme Court of India on the Adani stocks issue. The committee's conclusion, para 62. At this stage, based on all the information provided by SEBI, it is apparent to the committee that SEBI has been suspecting 13 overseas entities of having links to the promoters of the Adani Group and thereby suspecting that the shareholding in the listed Adani stocks in the hands of these 13 overseas entities need not qualify as public shareholding. B. If such holding is not public shareholding, the listed Adani companies would have violated Rule 19A of the SCRR. C. At this stage, each of the 13 overseas entities have provided the details of the beneficial owners to the respective reporting entities and to SEBI in compliance with Rule 9 of the PMLA rules. D. According to SEBI, there is no demonstration that the persons declared to be beneficial owners are not beneficial owners for purposes of Rule 9 of the PMLA rules. E. Both the Adani promoters and the FBI's beneficial owners appear to have affirmed on oath that the FBI investments are not funded by the Adani Group. F. In the instant case, it appears that SEBI is not able to make out a case, and such a position of the case not being made out is presented as a prima facie position which cannot be confirmed unless more investigation is done. In any prosecution of proceedings, whether civil or criminal, the presentation of a prima facie case is the responsibility of the plaintiff or the prosecutor. Once a prima facie case is made out, the burden shifts to the accused. G. The inversion of the process of proving a charge leaves the matter in the realm of suspicion. It is strict law that suspicion, however strong, cannot replace proof. However, the publication of the Hindenburg report has reinforced SEBI's suspicion that perhaps there is something amiss, and it desires to probe this further and is seeking time. H. Even the fundamental rules of evidence would require a conclusion of whether an allegation is proved, disproved or not proved. At this stage, the actual metric appears to be to place the matter in the realm of not proved. The regulator has not been able to prove that its suspicion can be translated into a firm case of prosecute an allegation of violation. Related party transactions. March of the law. Para 63. The SEBI listing obligations and disclosure requirements Regulations 2015 LODR regulations came into force on December 22, 2015. Para 64. These regulations define the related party transaction in Regulation 21ZB as a transaction involving a transfer of resources between a listed entity and a related party regardless of whether a price is charged. Para 65. The term related party in Regulation 21ZC had the same meaning ascribed to it under Section 2 within bracket 76 of the Companies Act 2013 or under the accounting standards. Para 66. The definition of the term related party was amended to take effect on April 1, 2019 to provide that any person or entity belonging to the promoter or promoter group of the listed entity and held 20% or more of the shareholding in the listed entity shall be deemed to be a related party. Para 67. This amendment was based on recommendations of a committee on corporate governance which made a report dated October 5, 2017 containing various recommendations on corporate governance. The recommendations were put out for public debate and after detailed deliberations these changes were made. Para 68. Subsequent amendments made in 2018, 2019, 2020, 2021 and 2022 changed the provisions that imposed regulatory obligations on related party transactions, but the definitions of related party and related party transaction were left unchanged. Para 69. On November 21, 2021, the regulations underwent substantial amendments yet again, but the amendments took care to ensure that amendments took prospective effect and that too from a deferred date. Most of these amendments took effect on April 1, 2022, but some specific amendments made in this round were given even a further deferred date to take effect April 1, 2023. Para 70. In these circumstances, the definition of related party was amended to include persons holding 20% or more in the listed company, whether directly or indirectly or on a beneficial interest basis under Section 89 of the Companies Act 2013 within the ambit of the term. With effect from April 1, 2023, the deemed inclusion would bring within the scope of the term related party persons who so hold 10% or more of the listed company. Para 71. The term related party transaction was also amended with a similar deferred prospective effect to expand its scope to cover transactions between a listed entity or any of its subsidiaries on the one hand and a related party of either the listed company or its subsidiaries on the other. So also, to further the spirit of the regulatory coverage, the term was amended to include transactions between a listed company or its subsidiary on the one hand and any other person within bracket, even if not a related party, close the bracket, if the purpose and effect of the transaction is to benefit a related party. Para 72. These amendments were necessitated to address the mischief or contrivance of effecting a transaction involving a transfer of resources between a listed company and a third party which is not a related party, only to technically escape the rigors of compliance applicable to a related party transaction, to thereafter transfer the resources from the unrelated party to a related party. Para 73. Suitable exceptions are made for transactions that have a uniform effect for all the shareholders on a pari passu basis in proportion to their shareholding. Transactions such as dividend, bonus issue, rights issue, buyback, etc., which are offered to all shareholders in proportion to their shareholding. Para 74. The above said summary describes the key to understanding the scope of the terms related party and related party transactions. A comprehensive extract of the provisions defining these two terms that would show the movement of the various amendments is set out at Annexure B to this report. Allegations on related party transactions. Para 75. The committee asked SEBI to comment on each of the transactions referred to in the Hindenburg report to enable the committee to carry out its remit. After a detailed initial presentation made on April 2, 2023, SEBI made a more detailed presentation on these transactions on April 26, 2023. Para 76. The Hindenburg report refers to over 6,000 related party transactions and questions their appropriateness. That apart, 10 transactions have been assigned as related party transactions that have not been disclosed but allegedly ought to have been disclosed. Para 77. SEBI has submitted that the transactions assigned in the Hindenburg report could be classified into 5 types of structures. These are: A. Two-step structures. Structures where the second leg of a transaction involves a listed entity and is disclosed, but the first leg of the transaction is between two private unlisted related parties. The two legs could be proximate or distant in time. The two legs are, however, alleged to be connected to each other on the premise that such connection makes the two legs of the transactions combine into a composite related party transaction. B. indirect or intermediated structures. Structures where the first leg of the transaction is between a listed entity and an unrelated party and therefore not disclosed. The second leg would be between such third party and an entity that is a related party to the listed entity. The two legs could be proximate or distant in time. Neither leg is disclosed, each of it falling outside the definition of related party transactions. C. Associated party versus related party structures. Structures where the transaction is between a listed entity and a third party that is closely associated with the promoter. However, third party is not a related party as defined in the regulations, and therefore transactions with such party are not disclosed specifically as a related party transaction. D. Subsidiary company structures. Structures where these transactions are between a subsidiary of the listed entity and a related party. Such transactions not strictly involving the listed entity on the one side are not treated as a related party transaction. E. Allegedly questionable RPTs which have been reported. Structures that already come under the ambit of RPTs under SEBI regulations and have been disclosed, but where their appropriateness is questionable. Para 78. As regards transactions that are reported as related party transactions covered by subpara E above, it would necessarily follow that questioning their appropriateness by the market could be based on an opinion on business judgment but cannot be based on alleged violation of law. But differently, if a listed entity is compliant with the law, the scope for discussing a violation of the law stands eroded. The appropriateness of the transaction may be subject matter of comment by the market. Competing and conflicting opinions would inform price discovery of the securities issued by such listed entity. Whether the comments are fair or unfair, appropriate or inappropriate, are all matters covered by free speech and expression, subject to the reasonable restriction imposed by validity made by regulations on the obligation to speak the truth and not misrepresent the truth. Para 79. The focus should then shift to the transactions that are not disclosed on the premise that they are not related party transactions covered by subparas A to D above, and to then consider if they are related party transactions masquerading as transactions with unrelated third parties. Para 80. As seen above, the regulations defining related party and related party transactions have been constantly amended to expand their scope and bring within its sweep the transaction structures referred to above. Para 81. One regulatory approach would have been to test such structures on the strength of the regulations as they existed at the time the LODR regulations were first notified. Section 12A of the SEBI Act 1992 outlaws contrivances and devices that are structured to circumvent the law in effect, a framework against anti-avoidance. Para 82. However, another regulatory approach is to make amendments to spell out what would be covered by the legal requirements. With related party transactions over the years, SEBI in its legislative capacity has consistently and consciously chosen this path. The march of the law governing related party transactions is articulated in the section above. Para 83. The Constitution of India lays down a fundamental principle: all actions of human ingenuity are deemed to be permitted unless validly made by law makes an intervention and restricts it. Such interventions need to withstand the test of being intelligible, being recent, and not being arbitrary in order to be constitutionally valid. The rule of law is not that unless explicitly permitted, human action is prohibited, but that unless explicitly prohibited, human action is permitted. Para 84. SEBI submitted that no matter what the regulations stipulate, there will always be a structural vulnerability or an intrinsic opportunity to structure transactions in a way as to comply with the letter of the law while not necessarily abiding the spirit of the law. While SEBI submitted to the committee that the committee ought to recommend introduction of provisions akin to the general anti-avoidance rules that are now in vogue in tax laws. The fact remains that Section 12A of SEBI Act 1992 is but a provision enabling anti-avoidance action and has been in force right since October 29, 2002. Please like the video, subscribe to the channel, give your comments. Thanks for watching.